Hello and welcome to the Minimum Competence episode for Friday, May 8th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Trump's tariff setback, New York's proposed ICE mask ban, and Illinois' push to limit investor influence on law firms. Let's remember, fortitude is the guard and support of the other virtues, and read today's legal news. On this day in legal history, May 8th, 1945, the Allies celebrated Victory in Europe Day, or VE Day, after Nazi Germany's unconditional surrender brought the European theater of World War II to an end. The surrender did more than end a military campaign. It opened the door to one of the most important legal reckonings in modern history. In the months that followed, the Allied powers created the International Military Tribunal at Nuremberg to prosecute major Nazi leaders for crimes against peace, war crimes, and crimes against humanity. These trials helped establish that individuals, including heads of state and military officials, could be held personally responsible under international law. That principle was a major departure from older ideas that treated war primarily as a matter between nations rather than as a source of individual criminal liability. VE Day also set the stage for the legal rejection of the defense that officials were merely following orders when participating in atrocities. The post-war prosecutions influenced later human rights law, including the Genocide Convention and the Universal Declaration of Human Rights. They also helped shape the Geneva Conventions of 1949, which strengthened protections for civilians, prisoners of war, and wounded soldiers. The legal aftermath of VE Day showed that victory would not be measured only by military surrender, but also whether law could respond to mass violence. It forced courts and governments to confront how ordinary legal systems had failed under fascism and how international law might prevent future atrocities. The Nuremberg legacy remains central to modern debates over command responsibility, aggressive war, and accountability for crimes committed during armed conflict. May 8th, therefore, stands not only as a day of celebration, but as a turning point in the development of international criminal law. A U.S. trade court ruled that President Trump's latest temporary 10% global tariffs were not properly justified under Section 122 of the Trade Act of 1974. The decision was narrow, blocking the tariffs only for two private importers, Basic Fun and Burlap and Barrel, along with the state of Washington. The tariffs remain in place for all other importers while the Trump administration considers an appeal, and they are currently set to expire in July. The court found that Section 122, which allows short-term tariffs to address serious balance of payments problems or protect the dollar, did not fit the trade deficits cited by Trump. Most of the state plaintiffs were denied broader relief because the court found they lacked standing, since they had not shown they directly paid or would pay the tariffs. Washington was treated differently because it submitted evidence that tariffs were paid through the University of Washington itself. The ruling follows a Supreme Court decision that had already struck down a separate set of Trump tariffs imposed under a national emergency law. The administration is expected to keep pursuing tariffs through other legal routes, especially Section 301 of the Trade Act, which deals with unfair trade practices. Lawyers and trade experts expect further appeals and possible lawsuits from other importers seeking similar relief or refunds. For now, the ruling is legally important but limited in practical effect because it does not stop the tariffs nationwide. New York is preparing to ban law enforcement officers, including ICE agents, from wearing masks during ordinary duty operations. Governor Kathy Hochul announced the plan as part of a broader agreement with state lawmakers on New York's 2027 budget. The proposal would allow masks only in limited situations where there is real operational need, such as the use of a gas mask. The budget agreement also includes immigration-related limits on cooperation between state law enforcement and ICE. Under the plan, state law enforcement will be barred from helping ICE carry out federal immigration actions. ICE would also be restricted from entering schools, healthcare facilities, homes, and other sensitive locations unless agents have a judicial warrant. State officials expect the Democratic-led legislature to approve the measures soon. Similar mask restrictions have been pursued in California and New Jersey. Those efforts have already drawn lawsuits from the U.S. Department of Justice. A federal judge struck down California's ban earlier this year, finding that it unlawfully discriminated against federal officers. That history suggests New York's measure is likely to face a federal legal challenge as well. Illinois lawmakers advanced an amended bill meant to limit outside investor influence over law firms. The state Senate Judiciary Committee approved the measure 8-1, sending it to the full Senate for further consideration. The bill targets arrangements involving law firm management service organizations, often called MSOs, and other non-lawyer-owned entities connected to legal practices. It would bar those entities from interfering with lawyers' professional judgment, hiring decisions, or access to firm documents. It would also prevent outside entities from charging fees tied directly or indirectly to a law firm's fees or revenue. The amended version allows law firms to repay loans or credit from outside entities as long as repayment is not tied to the firm's financial performance. It also narrows the bill so that it applies to Illinois lawyers and firms representing clients at least partly on a contingency fee basis. Lawyers would have to disclose MSO agreement to their clients. Supporters say the bill is designed to keep legal decisions in the hand of attorneys rather than investors seeking profits. Critics argue the bill is too broad and may interfere with the Illinois Supreme Court's authority to regulate the legal profession. The Illinois House already passed an earlier version, but it would need to approve the amended bill before it could go to the governor for his signature. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday. And until then, remember, the world breaks everyone, and afterward, many are strong at the broken places.